The Land Court Act, which intends to expedite the country's land reform program and address backlogs and disputes surrounding claims, was now signed by President Cyril Ramaphosa earlier this week. This measure will allow for the establishment of a permanent and specialised land court, as well as a land court of appeal to replace the land claims court. To break down the differences and how this intervention will benefit claimants, I'm now joined by legal analyst Mpumelelo Zikalala. Very good morning to you. Thank you for your time. Now, this law abolishes the land claims court and sets up the land court as a permanent institution to resolve these land disputes. What are the big differences?
I think that the other one is simply to say that we are now creating, or the government is now creating a process in which, according to it, would be much easier for claimants to go to court and resolve any matters of disputes that might be there. You would know that the space which was open for individuals to make sure that they're fighting their claims has come and gone, and there are some that are still fighting between their own. So in order for those processes to be adjudicated, then this particular land claims court is then created to then take on that space. What is unique about it is almost similar to your CCMA type of proceedings, in which you can go and have mediation proceedings and arbitration proceedings, while having the protection of having an order which is going to be issued, which is similar to that of the High Court. Some may say, though, why the need for a duplication? Why not fix or use the current process that we have now? We know that it's going to be a very expensive process. Once the land claim court has been created, it needs a judge president, it needs a deputy judge president. It needs someone who's going to sit in that particular court when you're going to make those particular establishments. So the finances which are going to be there in establishing this particular court, where do they come from? And then the most important question is, once those particular disputes or the backlog has been done and dusted, what then do you do with the infrastructure that you have created? Is it much better that you use the current process that you have? Just make sure that you're able to refine it so that you're able to deal with the blockages that might appear now and again.
Previously, I mean, you say it needs someone who will sit there because we know that previously judges who served on the land claims court were not full-time. What differences does that make to have a full-time judge really dedicated on resolving these disputes?
It means that you're going to have someone who ends up being a specialist when it comes to land claims court, similar to what we find in your maintenance court, in your family court. Someone who sits on a daily basis and looks at land claims and nothing else. So by the time they are finished with their term, for example, they would have been able to deal and be able to provide much better advice as to how to deal with the disputes and nature of disputes that is able to arise. Hopefully, the government will then be able to tap into them and say, what are the signs that are there that when we deal with these land restitutions, we must be careful of, and what type of agreements or clauses should we make sure that they're included in this type of agreement, so that you're able to close in the loopholes, maybe of corruption of people who will then submit frivolous claims, then makes it easier for all investigations to be done and dusted. So it would help to have someone who's going to be a specialist when it comes to come to land claims, but then the big question is, do you want to have that person permanently sitting in a court adjudicating these matters? Then what then happens while this adjudication has been done and dusted, maybe 5 years or even 10 years from now? Are you going to have fresh claims? Then what's wrong with the current civil system or the Superior Court Act system that you are currently using? Why not refine that instead of creating a new court altogether?
Refining it would be imperative because we know that one thing that's pretty clear here is that there's a backlog of cases, and that in itself will need some speedy and urgent attention.
Definitely. And the backlog is not created because there's no platform which is able to deal with this. It is created because the platform is there, just that it grinds very slowly. The reason why it's grinding very slowly is because there's lack of manpower, resources that are there, lack of technology which is able to be used. And what is most important when it comes to land claim matters is the researchers who are going to come in and say, yes, we know what happened 50, 30, or even 100 years ago. These are the indigenous people that were living there. We've done an investigation, and this is the type of report that we are doing. And at the end of the day, this is the real situation as to who are the real claimants of this particular process. So for me, the department has tried all it could in order to be able to resolve these particular matters, and their process were quite good. And simply to say that if a person is not happy, then go to the normal court system that we have, but look into that court system and make sure that you're able to refine it. What you are doing now, you are creating a structure which is going to serve in a very same manner in which your civil courts are working in, meaning the problems in which the civil courts are facing are going to be imputed to the land claims court, thus making it not that effective when it comes. So the idea is good and noble. However, we remain to see whether it's going to work or not. But judging from how our civil courts are running now in certain provinces, I do not think it's going to go optimally if we do not introduce, for example, technology, if we do not introduce things which are going to make sure that whoever is going to be appointed as a judge president there, or as a judge, by the way, are able to be held accountable in a number of matters and which are able to finish within any period of time.
How effective do you think this could be when it comes to restitution claims arising from the Restitution Act?
I don't think it would be effective that much. The problem is not the adjudication. The problem is the research and be able to prove that this is your claim. That is what is missing. And the person who is sitting there and looking at this information cannot adjudicate these matters without experts having provided them with the information. So if you want to speed up the process, look at what the blockages are. That when it comes to experts that are there and the resources which are then poured into this type of investigations in every financial year. So unless you fix those things, you are going to forever find those blockages which are going to be there. You can create the most perfect court system, but if the court system is not being fed or not being given information that can be able to adjudicate, you are going to have a judge present in a court building which is going to be open. However, there are going to be no matters that are going to be adjudicated due to them not being finalized as yet or not being ready for them to be adjudicated by the judges who are going to be appointed.
The concerning part here is the number in terms of a backlog. They're talking about 5,000 land claims which date back to 1998, the deadline of 1998, which really is quite shocking looking at the time frame and the expectations for this court. Let's perhaps expand a little bit on what this court could actually achieve and tackle when it comes to priorities of people in rural areas?
I think the idea behind the court was to say, if we have a specialized court that deals with these land claims on a daily basis, so that's the only thing they look at. They're not going in a civil court which will deal with divorce matters and other matters and interdicts on a regular basis. So come to a court which is going to deal with land matters from morning up until sunset. Then it makes it easier for the presiding officer to then say, this is the system in which we are providing. There are mediation processes which are then open and available within the Act. So it makes it easier to then say, rather than fighting, let's negotiate and try and find a amicable solution. It makes it easier to adjudicate those matters. However, I'll come back to the point that I made earlier. In order for you to be able to make that particular assessment, you need to make sure that the research and the information which is going to be provided to you as the presiding officer for you to enable you to adjudicate has been prepared accordingly. If the backlog or the problems is the production of that particular information, and then you're back to square one because you have a process which is able to adjudicate, however, you don't have the information which is required. For me, for example, I would have said, rather have private legal practitioners who are going to come in, be appointed in a panel or in any other process that is there, and simply say to them, you've been allocated 50 matters in which you must try and resolve within a period of 6 months. If there are any backlogs which are going to be there, please come and tell us so that we're able to fix it on a regular basis, not to create a new system. Let's look at it from the side of finances, for example. Human resources alone. The minute you create a complete separate court system or a specialized court, it means that you have a judge president of a president of that court, you have the deputy president of that court, you have other judges that are there. They need secretaries. You need a building which is going to be there. You need HR which is going to be there. You need security. So why engage and take all that money and plow it into human resources when you can take that money and plow it into consultants or legal practitioners who are going to adjudicate matters on your behalf? This thing could have been curtailed maybe within a matter of 36 months if you engage in that particular process.
Yeah, very well. Thank you so much for your time. Let's perhaps leave it there for now. Legal analyst Mpumelelo Zikalala there speaking about the impact of this court and what it could do and some of the challenges that may lie ahead.